Ward.
Stefan Krakauer, 5th Ward / Deputy Supervisor.
Please, Salvatore Town Clerk.
Jim Nelson, attorney for the town.
Now what, Felicia? Okay. First item on the agenda is a proposed nuisance law dealing with nuisance parties. Second item is to set a date for a special town board meeting for July 16th. Number 3 is resignation of Julie Reed, police assistant. Number 4 is purchase of mini caliber robot, police department. Number 5 is approve referral Dahlia Route 9G project to the planning board. Number 6 is authorize supervisor to sign Dutchess County supplemental agreement number 4 for Spring Road. Number 7, approve standard workday for elective appointed officials. Number 8, notification Springside Neighborhood Development reaffirm planning board secret lead agency. Number 9, approve block party Conklin Street to be held August 16th. Number 10, approve block party Orchard Park to be held July 26th. 11 is authorize the signs for Hudson Valley Historical Miniature Guild Scale Modular Society. 12, authorize SECRA Country Club Sewer District SECRA map plan and report expenses. Number 13 is the SECRA lead agency for the Country Club Sewer District. 14 is authorize supervisor to sign Arlington Fire Department easements agreements. 15 is authorize Key Bank agreement. 16 has been removed from the agenda. Number 17 is rescind appointment of Thomas W. Colgan Water Department. Number 18 is rescind appointment James Normandine Water Department. Number 19 is a property maintenance public hearing for 107 East Cedar Street. Number 20 is a property maintenance public hearing for 102 Creek Road. Number 21 is a property maintenance for 32 Lindbergh Place. Number 22 is a property maintenance hearing for 83 Fairview Avenue. 23 is a property maintenance public hearing for 6 Alexander Boulevard. 24 is a set a date for public hearing for property maintenance for 16 West Dogwood Drive. 25 is notification of claim for Donald Kramer versus Town. 26 is authorized special consents. The special SC1 is property maintenance for 187 North Grand Avenue. SC2 is appoint Carl Osterman part-time permanent court attendant, and SC3 is notification of a claim to be referred to legal, Tom Wolven v. Town of Poughkeepsie. I'd make a motion to suspend the rules for public comment on agenda items.
Second.
Motion's been seconded, and motion's moved and seconded. All in favor?
Aye. Aye.
Anybody have comments on the agenda items? Doreen?
Question about agenda item number 5, referral for Dahlia Route 9G project. Isn't this the same item that was on the agenda back in May as LVS, where they wanted the senior housing overlay? I was wondering why the name changed.
I believe so.
It's the same project.
Okay, it's just, no.
I haven't heard anything or seen anything about it since then, so I don't know, but I believe it's the same project.
Okay. Then my other question is, in the packet online, I saw that for number 12 and 13 for the Country Club Sewer District, that they were hiring a wetland delineator, and I was wondering if there was going to be any wetland disturbance on this project, or was this to avoid disturbance?
Don's not here, but I believe that this pipe and the easement around it, pardon me, will skirt protected areas, but Don needs to have it delineated to make sure that that's the case. Is that correct?
It's part of the secret process.
Right.
And we have to certify to them, so they hire the people that can do that.
Right, I understand that. I'm just concerned as to whether there was going to, if you knew there was going to be any wetland disturbance, but it sounds like from what Mr. Nelson said, this could be a case of where you're trying to avoid wetland disturbance, because I believe that's a couple of acres, so that would be a 25-foot buffer. Okay, and then my only other question is number 11, signs for the Historical Modular Society. Why does this come before the board and not go before zoning, or not before zoning, but to the zoning department for permits? Why is this different?
Are they sandwich board signs or what is it?
They're little like political signs.
Right, no,
You
I
know,
understand what they are,
I
but,
think we don't make him get a permit, so waiving the fee, we let him put like 10 or 12 up around the town, he gets them out of there within a couple hours after
Only
the
the town
event.
board can waive fees.
okay, so that's specifically what this
Is that
is
what it's
for,
for, to waive the
to,
fee?
because other, okay,
So
so,
originally it was a type of sign.
That's what it is now. It says signs, doesn't say fees.
Yeah.
I mean, I know it comes up every year.
Number 9,
Approve it.
to waive. Open.
For some reason, I thought the type of sign wasn't permitted, so the town board had to waive
Maybe it was the
type of sign to allow it.
signs.
I
okay.
think so.
He's done this for a number of years. I'm not quite sure why.
I forgot what
Everybody
signs
else
look
votes
like.
yes, and I vote no every year.
Right,
but-
I was just wondering what was different
Everybody else
about
votes yes, I
these,
vote
where
no here.
instead of going to the zoning department, but I guess I can ask the zoning administrator.
Well,
Thank you.
But I think it's the zoning department can approve it because it's not a sign that's permitted under the town law, so it's got to come to the town board.
5 directional signs, which is not covered the other way,
Okay.
is
Yeah.
the way it was explained to me.
Okay, all right, thank you.
Anybody else? Woman in the back.
Hi, Georgette Martin. I want to talk about the nuisance law. Is the town board aware that Oswego canceled their pub crawl this year because 3 children, one died of a heroin overdose and 2 were hit by the trolley up there? So I really think our town board should consider having Marist cancel the pub crawl.
Well, I agree with you, we don't want the pub crawl, but it's not a mayor-sponsored event. So it's really up to the homeowners that allow the pub crawl to take place on their houses to get them on board to say, no, we don't want it there. And I think this nuisance law will eventually deal with that.
Well, I noticed in the paper, the nuisance law, you realize there's a lot of underage drinking going on there. Because the nuisance law has a provision there, what to deal with it, take their beverage away, correct?
It's one of the
Yeah.
things in there.
Yeah.
Well,
So it actually is a
the
public-
nuisance party law would allow the police department to shut down the party immediately. It would also, the way it's drafted right now, would allow the police to confiscate the alcohol as evidence if there's underage drinking occurring. I think that part of the problem is you got to shut the party down before it gets out of control. The other thing I agree with this law with is that you got to take the alcohol away, because if the alcohol stays, it'll get, the minute the police pull away, someone will start drinking it or it'll go to another location. So to me, it makes sense the way it's written and the way it's set up. And it's geared towards stopping these parties. It's, you know, we don't want them to occur. They become excessive at a certain point. And the problem is that these people are drinking all day and all night, and something bad is bound to happen. And we hope to be able to avoid that type of
Right, and there's also,
Right.
there's also provisions in here that the fine structure goes up to $5,000 in the same year. So if the same person keeps getting tickets, they're gonna get banged pretty good on that. Plus, there's also a provision in there that, you know, it does mention any person who's the owner or occupant does face some consequences. So it does cover everybody pretty much well.
Well, personally, I think the accelerated law is something that won't happen, because I've lived next to these pub crawls ever since they've been having them. And what happens is they have the big parties in this year, April and May. And by the time you would get to the $1,000 fine, they were home for the summer vacation. I mean, it's very bad to live in the area, as you know, Mike, in September, in May, and now they've started in April. I really think the town should consider banning the pub crawl.
Well, what this law does is it gives the ability to shut down the party immediately, and that's what we're trying to do. Banning it, if somebody says they're going to have a party, you can't go in ahead of time and tell them they can't do it and arrest people and take away their beer. But the minute they actually do something that violates the law, the police can get involved. This gives the police an additional tool to be able to deal with it. And the way it's written, it allows the party to be shut down immediately. So that's what we're trying to do, is stop this from occurring.
Okay, when's this become effective?
We'd like to get it in effect as soon as possible, so it's in effect before the beginning of the next school year, so that we'll be able to apply it right away. And this was something that came out of the police department. They looked at it as what they thought it would be a good idea to help them to do their job over there. And then a number of board members had worked on it to try to get it to the point where it's something that, would work and would be an effective tool, so, and I think it's there.
All right, well, we'll be singing about a month.
Let's
A
hope
month
so.
and a half. Okay, thank you.
Thank you.
Commissioner Armstrong. Mr. Armstrong. Commissioner Sir?
I'm not even going to mention my name.
Okay.
The woman that was just here and what she was saying is there part provision there for the landlords that constantly let this happen, that they're going to get zinged?
Yes.
Yeah.
That might help. The supplement on Spring Road, is this just to finalize some agreements as to who's doing what, or how's it going to be done? Or I thought that was all in the works and they were just waiting to start the job.
This is the part of the seeker process, State Environmental Quality Review Act.
No, they haven't
And to
done that
do
yet.
that, the town has to make certain statements to them on the application. And to do that, we have to hire individuals with that particular skills. One is archaeological, and the other is environmental. So those two individuals, the two things you see there, one is to walk the route of the new line to make sure that there's not some archaeological factor or thing or building or whatever. And the other one is for environmental, Blandings, turtles, bats, whatever, because we'd have to mitigate that, and the way it was explained to me, the expense of mitigating it is cheaper to change where the pipe goes. So
No,
that's what that's for.
I thought
It's-
that was already done and over. I didn't realize they still had to do that.
That's
Okay.
that's all the funding in the application process. Now it's the nuts and bolts. And this is one of the nuts or bolts, depending upon what you think of it.
They've got another thing, they've got a couple things in there about block parties. Conklin Street, isn't that in the city?
No, it's not, it's in Hamburg.
Oh, this is one from New Hamburg. And the other in Orchard Park, that's out in Red Oaks Mill, I believe. Is
Yeah,
that
that's
that
one in Red
Correct.
Oaks Mill.
Okay, I thought there's Conklin Street, there's a Conklin Street in the city of Poughkeepsie.
No,
But, okay, it doesn't say that here, all right. I think that's all for now, thank you.
Anybody else? Going once? Make a motion to resume the rules?
Second.
Motion's been made and properly second. All in favor?
Aye.
Aye.
Okay.
want to read
Oh, well,
one?
Yeah, I guess,
Go further.
what do we want to do with this? Do we want to read it, or Bill, do you want to do something
I
to?
think what I'll do is, we'll make a motion for discussion. Second it for discussion.
I don't think we need, do we need a motion
We
for?
don't have to. Unless you have
just
something to bring up
discussion
on it.
I think you could without the motion. if you
Without the
want.
motion? Okay.
Happy with-
This is the nuisance party law. This came out of, I think, our June 11th board meeting. And we did some research. There's been a lot of work done on this by Jim Nelson, by Stefan, by the chief and some of his captains, and by me. And the idea was to try and impact those individual things that we see are making this a bigger and bigger problem. We have to do it according to the way the laws can be administered. So basically what we have is there are three individuals, defined people under the law who can be held responsible. The first is a responsible person. That'll be the people that organize it, sell the tickets, get the porta potties delivered, and the T-shirts. The second would be a person attending. For example, this crawl they had, the individuals attending go to one, and then they go to the second one, and then they go to the third one, and they go to the fourth one. That would be a person attending, and under certain circumstances, the person attending can be given a ticket. The third one is the property owner, and that is one of the first changes I want to make from the draft, if it's okay with my fellow board members. Property owner can become liable for the same fine, the same ticket, if the property owner has received 2 notices of conviction. That sounds simple, it's not that simple. There has to have been a prior nuisance party on that piece of property where somebody was cited by the police department and convicted of that violation. Then the property owner gets a copy of that notice of conviction. If there's a second party and a second notice of conviction is issued and sent to the property owner, he's now, he or she is presumed to have knowledge of the third party. At the third party, they get the ticket, 7 days in jail or up to $1,000. I don't think there's any property owner that we have anywhere in the town that would intentionally try to hurt his neighbors or make a bad thing in the neighborhood. Now, I went to college. I went to beer parties. I hosted a beer party in an apartment on Hammersly Avenue. It's well beyond the statute of limitations. I was the entertainment chairman for Gamma Phi Fraternity in Buffalo, and I ran parties for a year. I can tell you without a doubt, the police never came to one of them. I was a policeman here in the town of Poughkeepsie. I was sent on these calls, and I was a boss, and I had to run cops at them. So I can understand from both perspectives, but I do think that we need to give the police department a stick. Now, the way that it's discussed for this to be done is that this fall, the community relations sergeant in the police department, Sergeant Hurlbut, will walk Fairview and speak to each group of students and give them copies of this law. Marist is going to be given a copy of the law. I hope they publish it in a student newspaper. The idea is that it will prevent the party from happening. If the party still happens, they have been clearly notified, warned, told of the penalties. If they have a party, then the police department will do what has to be done.
I think this having 2 prior convictions is too lenient, that they should actually just have 1 prior conviction, because it takes many months for this to actually go from an arrest to a conviction, if it makes it to a conviction, and there could be several parties in between that time. And this could take way too long and too much disruption in the neighborhood, that I think 1 conviction is one enough, that they should be put on notice then, and then the fines start at the next conviction.
We're talking about the property owner.
Just the property owner, yes, because the other responsible people get fines with the initial convictions.
But the reality is, we're looking at a nuisance party ordinance. One party in and of itself doesn't create a situation where the property is a nuisance. The idea that you notify somebody once that something happened, I'm guessing that you wouldn't be evicting anybody at that point. You wouldn't be doing anything else. There'd be, warnings to, tenants or whatever. 2, I think, is reasonable because of the fact that something happens once and it could be an anomaly, or it could be something that, the landlord made a good effort to try to deal with and it wasn't followed through on the tenant side. I mean, we're living in a world where you should be allowed to do something. You should be allowed to, have people over. One party in and of itself doesn't mean that all of a sudden you have a property that's a nuisance. It means that somebody had a party. I'm guessing, you may have had parties at your house yourself. A lot of people have a New Year's party and a 4th of July party. That doesn't create a situation where you say, geez, these people are out of control. It's just, people get together from time to time.
Yeah, but
I think
the police weren't called. The police weren't called, nobody came out.
But it's what we're trying to get at is the houses that are real problems. And the property's a real problem.
Yeah, and that's why I'm saying if you
Town-
actually have a conviction for this, you have a house that's a real problem.
You're right. But you have to understand the legal hurdles that have to be come over. The landlord has given the people that are having the party a lease.
Right.
They're entitled to the property. If we're going to charge the property owner for the actions of the tenant, we have to go well beyond what it would be for the people that are running the party, because they don't technically give permission for the party. They're not hosting it, they're not paying for the beer. There was quite a discussion at some times with some raised volume by several members of this board over this particular area. But based on advice from council, if we allow to go to the second notice of conviction, so 2 violations that are resulted in convictions, there is absolutely no problem with then holding the property owner as a responsible party. In other words, we can't go in and tell the landlord, here's your ticket with one violation. But we can if there have been 2 prior convictions and the property owner's been told about it.
And I think it is a stretch to hold the landlord responsible for the actions of their tenants, because if you do it in this case, if your tenant sells drugs, does the landlord all of a sudden become a convicted drug dealer because the tenant sold drugs? If your kid living under your roof has a DWI, should you be charged with DWI the second time he or she has one? I mean, it becomes a situation, you're trying to impose liability on somebody else that doesn't have control over the property. A landlord, when you rent out your property, you give up that control to your tenant. You can't just kick the door in and say, I heard you were going to have people over, I want everybody out. The landlord doesn't have that control. The idea was to have some sort of reasonableness, but also to be able to.
Well, it's also to give the landlord some incentive to put some clauses in their
Yes.
leases to say, no parties, or you can't participate in the pub crawl.
I'm convinced that legally you'd be able to hold the landlord responsible if their tenant had
This
one
is-
party.
There was one community that has a large school in its area, and they went at this from the zoning law. They made the person who wanted to have the apartments come before the zoning, and as part of the zoning process, they were required to put a paragraph in their contract, the lease, saying that if you have a party and the police come, this lease is null and void. Well, from what I understand, in New York State, as a municipality, we can't tell 2 private individuals what they're going to put in their contract, in their lease, in this state. So the structure of it is to have the reasonableness in, so that when the property owner is issued the ticket, that he's had 2 prior notices of conviction. He is now presumed, or she is presumed to have knowledge, and therefore granted the party to happen, and therefore they violate the section. First offense is up to $1,000 or 7 days in jail. Now, what I'm told by people who are landlords, they'll probably immediately on the first notice, throw the people out. There's no doubt that that's going to happen. But there's an eviction process.
Right.
This party that they just had, there were 5 houses. They went from
Right.
one to the next to the next. That's 5 violations in one night. Plus now we're allowing the people attending to be cited. So the 300 kids walking around in Fairview now each get a ticket.
And this
Each party they go to. So if they make it to all 5, that's 5 tickets at up to $1,000 apiece. Do you see how this works? In other words,
I understand how this,
there's a great amount of don't do this,
right.
which I think is the safest way we can do it legally.
And this is
I
also-
do have one thing that I want to bring before the board to consider for change. And that has to do with these notices of conviction. Any person, any reasonable person as a landlord could get the wrong tenant, and there could be a problem. And that could happen with garbage or whatever else goes on in an apartment. In this case, it's the party. So now that property owner gets a notice of conviction. If the property owner corrects it and there's no more parties, this law, as I've recommended to you now, that notice of conviction stays there forever. I mean, that's a little wrong. That's a sword of Damocles hanging over people who are trying to do the right thing. So what I'd like to do is, I'd like to add words in under responsible person B, under 2, where we go, a property owner has been notified by the Town of Poughkeepsie Police Department of 2 prior convictions for violations of this chapter occurring within 2 years. So if there's only one, it goes away. That person who owns that house doesn't have this hanging over them. They did the right thing. There's no reason that they should be penalized anymore. So I'd like to, for us, for what we're going to pass, put that in. But I think we're pretty safe with 2 notices of conviction. And the event that we're talking about, there could have been 5 that night.
Yep, but
Right,
it's
and the other thing-
different property owners, I assume, unless it's one unfortunate
But-
property owner.
But the other
has
thing is, that
multiple.
this is a town-wide ordinance, so, we can have kind of collateral damage if we're not careful about writing this thing. I mean, this will apply to any rental property or any property throughout the town.
Right.
You want to make it make sense for everybody. The reality is, where there's those college parties, you could get 2 violations within 10 minutes. You could get them within 48 hours. Usually the houses that become a problem are right up there on the radar from the get-go.
Right.
And it's usually not the first party or the second party. It's when they start to build up. The house crawl, from my understanding, is generally the seniors. And what happens is, these people, so whoever starts to organize it has been thrown the last group had thrown parties a number of times. They had been written up for other violations previously. What I think we want to try to do is be able to get it so that we can prevent these, we can shut them down when they happen, we can confiscate the beer when there's underage drinking, and then we can get the fine structure to be high enough, so by the time they have their second, third, fourth parties, the fine structure is high enough so that we're also taking away the profit margin, because some of these kids are making a good amount of money off these things. So you got to try to figure out all the ways to stop it and prevent it. And I think the way it's written with the suggested change, I think it's make it fair, even-handed, and I think the application of it by the police department will make a lot of sense. And again, when you have a problem property, it's not a mystery. There's probably no confusion with the 4th Ward councilman or the chief of police which properties over there were a problem last year.
Right.
And that's why I say, I think you could say 2, you could say 1, 2, 10, 20. Some of these properties, you could probably get them up to that point very quickly. And the goal of this, I think, is to take those properties and say, just stop. Tell the kids to stop, tell the property owners to stop. The fine structure goes up quickly. The property owners, you should give people a reasonable opportunity to try to address it. If one thing happens, it doesn't mean that you've gotten a bad tenant. 2 things and the tenants continue to do it. At that point, I do think that the property owners have to take responsibility in telling their tenants to cut it out. You got to be out there. You got to be proactive. You can't, if you're an out-of-town landlord, you know what? Maybe you got to take a drive up to Poughkeepsie, New York once in a while and just make sure your tenants are being reasonable. If you're a local landlord, you should be over there on some sort of regular basis to make sure your tenants are being reasonable, whether they're college kids or anybody else. So again, this is a town-wide ordinance. We don't want to raise a hammer and start pounding everybody all over town. We want to make sure that the people that just can't behave themselves and obey the basic code of common decency get put up on the radar, start getting hit with fines. We shut and I think the biggest part of it, and one of the things I think the person alluded to that spoke was, these kids are graduating. It's May, and they're on their way out. The reality is, whatever you do at that point, if it's $100 fine and you can't do it again, they don't care. But if you shut the party down, take away their alcohol, that kills the party. That keeps the neighborhood calm. It keeps the neighborhood in a decent situation. And I think that's the biggest part of this, is being able to shut that party down and make sure that alcohol doesn't get consumed that night. And while the college kids throwing these parties may not appreciate it at the time, this may save some people's lives, and that when someone's drinking from noontime till 1, 2, 3, 4 in the morning, bad decisions get made. If you take that alcohol away, those bad decisions never happen. Those people go home disappointed and angry, but they go home safe and sound. So I think it makes sense. I think that the suggestion makes sense. I would support
I
it.
kind of agree with you about the property owner should be held responsible quicker. They're letting this happen. But the truth seems to be that, let's say that this particular property owner is a reasonable, very good person and didn't want it to happen. It happens, they get the notice of conviction. I'm sure that lease is going to be gone. I don't want it to hang over their head more than that.
No, I'm
But
fine
the
with.
one that tells
here.
you, like we had happen,
Yes,
so what do you want me to do?
yeah, exactly.
So what do you want me to do is going to get himself a $1,000 fine. And if there's 2 parties at his house, it's up to $2,500. And if there are 3 parties at the house, and I understand we have several houses that will happen in the fall, we're up to $5,000. It becomes very prohibitive for these things to happen.
Right.
But I think we'll be then, if there's a challenge to it, we're reasonable in notification to the property owners. I have no problem with the responsible person who's running the party.
Right.
Or the people attending the party.
Right.
Police come and tell you to leave, you don't leave, here's your ticket. But the property owner, I think, we have to give them the benefit of the doubt and be exceptionally reasonable. So if there's a problem and it's a challenge in the court, we're reasonable and we're within lines.
The question I have for our attorney, can we put a minimum fine in there? So that,
Yes.
right out of the, my suggestion would be the minimum fine should be $250 or $500.
It should be more than noise ordinance. It should be, noise ordinance minimum is $250, there should be $500 minimum for
The
the.
noise ordinance has a minimum fine of
You're talking about for the first violation, which we say up to 1,000?
Right.
Yeah.
You want to make it from a minimum of 250? The minimum fine is 250 with a maximum to 1,000?
That would be my suggestion. So this way,
Noise ordinance on the first is up to 1,000.
is there any minimum?
We do,
Okay.
we,
My suggestion then would be to put a minimum of $250 so that any one of the people who violate, whether it's the person throwing the party, whether it ends up being the property owner, or whether it's the people attending the party, they're looking at a $250 fine, which would curb the behavior and the activity.
We're trying to stop these things before they become a nuisance. You gotta hammer them first off. $500 would be a
You
good
gotta
chunk.
think, normal property owners too. They get
Right,
caught up in
that's-
this too. You wanna make sure.
right, that's my-
you know,
yeah.
Small party they have by accident, and not getting along with their neighbors, so, I understand, Maris has stopped, and Vassar, it's not just Maris. Vassar has their few over there too. We definitely have to do it. The property owners are responsible. We gotta make sure you follow these kids, because if you go and you evict him in October, he's not getting out till November. By the time they find a new house in March or somewhere else, that we follow the person too. Not just,
It's the
the property
person.
owner. It's the person that's gonna have that party. If you throw them out, in October, they're gonna find another house somewhere else. You wanna make sure you follow the person where they're going. Make sure that's covered in here too.
So what do you think of the minimum fine of $250?
$250 is nothing. I mean, they should do that with parking tickets, but.
No, well, the minimum.
Gotta hurt,
Make
right?
sure,
Yeah.
for the younger people getting hit with this, minimum, $250 minimum fine is a good amount. 1,000 for, up to $250 to up to 1,000 means that no matter who gets, if they get written a ticket for this, they automatically are on the hook for at least $250, potentially up to 1,000. I just think the minimum fine makes sure that no matter who is in court, as far as, the attorney on our side, they're getting, these people are getting hit with $250 first time, no matter what happens, and there's no, no negotiating that down beyond that, but it could always go higher.
We have to do a better job of keeping track of these individuals as well. They've gone to court, we've had a couple that have gone to court a number of times, and they should have been hit with a higher fine on that
Same.
second, third, and fourth time.
That's what I was thinking. You had said that before.
okay.
Yeah.
Okay, so do we have like a consensus with the draft in front of you, those two changes, the one with the minimum fine and the one about 2 notices of conviction? And if there's only one, it goes away after 2 years?
Yeah.
It's fine.
Everybody okay?
So we'll put it on for,
We're going to ask for a special meeting. We'll put it on for the publication and notification next week. We can vote on it at the last meeting of the month, and it can be effective right away, so that it can be given out to the students when they start to come back in August.
yep, all right, sounds good. Number 2.
There's also a typo that I'll fix.
Be it resolved, the Town Board of Town of Poughkeepsie is hereby call a special Town Board meeting on Wednesday, July 16, 2014, 7 p.m. before the committee of the whole meeting at Town Hall, Town of Poughkeepsie, 1 over Rock Road, Poughkeepsie, New York, for the following. 1, set a date for a public hearing on nuisance local law. 2, any other matters that may legally come before the board. So moved.
Second.
Motion's been made and properly seconded. Any discussion on? All in favor?
Aye.
Opposed? Abstentions? 2, 6,
5.
5, 0. Motion carries.
Resolution 3, be it resolved that the Town Board of the Town of Poughkeepsie does hereby accept with regret the resignation of Julie Reed from the Town of Poughkeepsie Police Department from her position as police assistant effective Friday, August 1st, 2014. So moved.
Second?
Motion has been made and properly seconded. Any comments? All in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0.
Whereas the Town of Poughkeepsie Police Department wishes to purchase an iCore Technology mini caliber robot with necessary features as outlined in the attached quote for use by the Town of Police Department, the purchase of which will be funded fully by a Homeland Security grant to the town in the amount of $99,985. And whereas the mini caliber robot is the only robotic product having the view, height, arm reach, mobility, and stability required for law enforcement purposes, for which it will be used by the Town of Poughkeepsie Police Department. Now therefore be it resolved, the Town Board, Town of Poughkeepsie does hereby authorize the purchase of a mini caliber robot with necessary features from iCore Technology Incorporated as a sole source provider, and be it further resolved, the purchase of this equipment is a type 2 action required, no environmental review. So moved.
Second.
Motion has been made and properly seconded. Any comments?
Yeah, what sort of situations would this be used for?
Keep board members quiet.
Sort of like R2D2.
Good evening. The competitive grant we were awarded from the state was it was a $2 million competitive grant fund in which established tactical teams that had met certain requirements and had been fully established could request equipment for domestic terrorism incidents, active shooters, or other high-risk tactical procedures. The equipment in the past has been very large, it's been very unreliable. Technology has come a long way at extreme cost to our military, and our military has kind of refined how this equipment works. So this device weighs 40 pounds. You can put it in a backpack and someone can carry it, fit in the back seat of a car. Gives us video technology, gives us audio technology, gives us some other things that we can do that I really wouldn't want to advertise, but there's enough done in movies and on the internet to give away a lot of our secrets. The problem we have is the town as complex as it is, with the 23 schools, the college campuses, and some of the calls for services we're experiencing, is that we have to ask officers to go down into basements looking for suspects, possibly armed, up into second floor residences, large commercial facilities, malls and things like that, and the schools. So what the state looked for we were the only team in Dutchess County to be awarded these funds. They were looking for a sound strategy on the part of our department on how we plan to respond to high-risk incidents in our community. And this device will be used as a life-saving tool because of its portability and its ability to gather intelligence that previously I would have to ask a police officer to put himself at risk to do. So I'd rather use a machine and gather the intelligence and putting a cop at risk.
Can it go up and down stairs?
It can go up and down stairs.
Really?
It can work in a wet environment.
How intensive is the training on it? Is it?
The company will provide the training over a course of 2 days. And all these grants require us to share this resource. So if the state police has one and if theirs went down, this would give them redundancy. And then this resource would be available and we will train any area police agency interested in learning how it works. I suspect from what I watched, it's not a large learning curve. You just control it with a remote controller.
Wow.
And then the area departments that might need it can call upon us. They can send a police car up, we put it in their backseat, and off they go.
It's a very impressive grant.
We were fortunate to get it, and it was, I think, because of the hard work of a lot of people in the department, the way they wrote the grant and explained that we do have a strategy and we do have a plan if, unfortunately, one of these disastrous events hits one of our schools or our places of work or worship.
And it doesn't get paid overtime, and it doesn't need benefits.
Moved and seconded.
Motion's been moved, resolution's been moved and seconded. All in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0.
Be it resolved, the Town Board of Town Poughkeepsie does hereby approve the referral of Dahlia Route 9G project application for a zoning amendment from residential, single-family, 20,000 square feet, R20 district to residential multifamily, RM district, and an application for a senior housing overlay district designation to the Town of Poughkeepsie Planning Board for a recommendation pursuant to Town Code 210154, and hereby consents to the designation of the Planning Board as lead agency for the seeker review of said project. So moved.
Thank you.
Second.
Motion has been made and properly seconded. Any discussion?
I'd like to have the full board look at this, because when they came before us before, we had questions and concerns regarding this project, and I'd rather have a full board. Oh, I'm sorry. I would rather you come back in committee of the whole and update us on the project, because this board had questions and concerns regarding this project before, and, you know, with the holiday weekend, and you can see we're missing a few people here, we just got this packet sent to us.
Yeah, and this wasn't brought to the land use committee, and I guess my question, because there were a lot of questions and concerns last time, I guess my question is how to make it back to the agenda already without any board members. I don't think, was anybody?
It's to designate the planning board.
Right.
No, I know, but-
We had issues with this project.
Oh, okay. All right. Yeah, I remember.
We issued a placement.
Rather than to come back to the committee of the whole, they selected to submit an application. They've submitted fees, they've submitted escrows. That's why it's here. Now, you could certainly table it and continue to work on it. There were questions that were raised about the original plan. The focus of the original comments had to do with the location of the driveway. They did meet with planning staff. We made some modifications to it, but you have not seen this except what was presented in your packet.
Well, why not? I guess my question shouldn't,
I mean, if we
The
had the
applicant
issues.
chose to take this route.
rather than communicate with the board that would be approving it? I mean, wouldn't it have made, I mean, normally this gets brought to the board.
My understanding of it was when we were before the board last month that there were questions relative to the driveway location and the buildings in the front. And so what we did is we reworked a plan that we thought addressed everyone's comments. And because there's limited meetings coming up in the fall, we were hoping to try to work with the board and the planning board and the town's consultants on addressing the site concerns that you have. But simply tonight, all that we're seeking is a referral over to the planning
Do we have
board
days off
just
in the
to
fall
start
that I don't know about?
the seeker process. That's
What do you mean limited meetings coming up in the fall?
There's no planning board meeting in August. So all that we're asking for is a referral to the planning board just to start seeker.
But
That's it.
I mean, I guess, because it ultimately requires a town board to approve it. And I guess my question is, I don't know why it didn't come back to either the land use committee or the town board or the councilman for the board.
We could have updated.
Got it, because there were a whole bunch of questions. The numbers were completely off. The design was less than fantastic. So I would have thought that it would have come back somewhere through the board to have a discussion
Then I
before.
incorrectly interpreted your comments because I thought that the comments that I got was, I know, Stefan, you had some comments relative to the location of the driveway, but I thought that the consensus of the
buildings.
board, maybe I misunderstood, was that they liked the concept, but understood that there were site issues that we wanted to resolve. And what we did is we went back and tried to make an improvement to the plan.
I guess my question is, why were there if there were offline meetings with planning, it would have made sense to have councilman from the ward, the land use committee, or somebody from the board involved as well.
I
mean,
thought that we were doing the right thing and
I
doing
think
it.
that the problem you're having is, in front of us now is a short form environmental assessment form, and it raises questions. The form indicates that there will be no traffic impact.
No, I don't think that's the problem. Problem is,
Yeah,
I
that-
don't think anybody was overly impressed to begin with. As Stefan saying, we would have liked to seen a second thing up front prior to it coming right in front of us, is what.
So?
This is all new to me. You have to,
Yeah.
I mean, I had a problem with the design last time, and just to see it in front of us, I thought we would either got a phone call, a contact ahead, are you happy with this, or, you know, really didn't see the change until just the other day.
Then
Yeah.
I apologize. I didn't
Yeah.
think that the comments were that
Why don't we
significant. I
table
know
this?
Stefan
Yeah.
specifically said.
Well-
Well, the concern is that if we do this, we're losing several months because there's no planning
Yeah,
board
but
You
meeting
can
in
always,
August.
you can
And-
always ask for a special planning board meeting. We have members, we have
I don't know if the-
alternate members.
But
I
all
just-
that we're doing is asking to
But
get
there
the-
should have been, there should have been communication with this board somehow. And again, the councilman, the land use committee, town board,
I thought that the communication was.
I was
limited.
actually surprised it was back on the agenda because I hadn't seen anything. I thought somebody else on this board might have, but the fact that nobody has.
I'm as
No, I
surprised
know,
as
but
you are right now.
We
The
just got the
normal,
packet.
the normal course of
Looked at the
business,
maps.
usually there's some sort of, I don't know if you'd call it vetting, but at least some sort of, input that's provided during the process. And the last meeting wasn't the smoothest, so it surprised me that it's back on the agenda without anybody from this board having any communication with planning or with the applicant.
We can table it.
Well, I guess shame on me. really, I thought that I was doing the right thing. And again, I don't mean to keep emphasizing this, but all we're asking for is a referral to
No,
the
I know,
planning board
no, I
to
know,
start
but
seeker.
wait,
That-
but
that's it.
referring,
But once we refer to the planning board, it's kind of.
this is something, that,
We
it's
have
referring it to the planning
like
board.
this project.
It's referring it to the planning board for input and their input on it. The input from the town board was that the board wasn't really happy with what was proposed. The numbers were off, the layout was bad. So I would think that before tripping over yourself to get to the planning board, you'd come back to the town board to say, we heard your comment, we heard your concerns, here's what it is. And I guess, Neil, why wasn't, I mean, isn't that what's supposed to happen? I mean, it's a.
Yeah, no, in the normal course, yeah. This should have gone before the land use committee.
Land use committee, councilman from the ward, anybody from the town board. I mean,
No, I understand.
It just doesn't, it doesn't make sense, tripping over ourselves to get it to the planning board is fantastic, except for the fact that the input last time was pretty much negative, less than fantastic. So I would have thought, I honestly thought when I saw it on the agenda that somewhere in the process, there was some sort of communication with board members to say, here's the revised process, here's the revised plan, here's the corrected numbers, but there's none of that, which is a problem.
You're correct, you're correct. If I could make a recommendation, just table the motion, make a referral over to the land use committee, and we'll take it up from there.
Motion to table and refer to a land use committee.
Second.
Thank you.
Motion's been made and properly seconded. All in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0. Number 6, is that me?
It's you.
Me?
Yours.
Two.
We saved it for you.
Oh, come on. Authorizing the implementation and funding in the first instance 100% of the federal aid and state Marchicelli program aid eligible cost of a transportation federal aid project and appropriating funds therefore. Whereas a project for the Spring Road reconstruction, Town of Poughkeepsie, Dutchess County, New York, PIN 8759.21, the project is eligible for funding under Title 23 U.S. Code as amended that calls for the apportionment of the cost such program to be borne, the ratio of 80% federal funds and 20% non-federal funds. And whereas resolution number 219 of 2014, adopted by the Town of Poughkeepsie on February 21, 2014, approved and agreed to advance project by making a commitment of 100% of the non-federal share of the cost of construction inspection, and construction supervision work, whereas it is subsequently found necessary to undertake additional construction work not contemplated in the original agreement authorized by the previous resolution, and whereas it has been found necessary to increase the federal and non-federal share of the costs for additional construction work for the project, and now therefore the Poughkeepsie Town Board duly convened does hereby resolve that the Poughkeepsie Town Board hereby approves the above subject project, and it is hereby further resolved that the Poughkeepsie Town Board hereby authorizes the Town of Poughkeepsie to pay in the first instance 100% of the federal and non-federal share of the cost of the additional construction work for the project or portions thereof, and it is further resolved that the sum of $125,000, $2,183,000 minus previous $2,058,000 is hereby appropriated from account H23 5110.0202 and made available to cover the cost of participation in the above phases of the project. And it's further resolved that in the event the full federal and non-federal share cost of the project exceeds the amount appropriated above, the Poughkeepsie Town Board shall convene as soon as possible to appropriate said excess amounts immediately upon the notification by the town supervisor thereof. And be it further resolved that the supervisor of the Town of Poughkeepsie is here be and is hereby authorized to execute all necessary agreement, certification, or reimbursement requests for federal aid and/or applicable Marchicelli aid on behalf of the Town of Poughkeepsie with the New York State Department of Transportation in connection with the advancement or approval of the project and providing for the administration of the project and the municipality's first instance funding of the project cost and permanent funding, the local share of the federal aid and state aid eligible project costs, and all project costs within appropriations therefore that are not so eligible. And it is further resolved that in addition to the supervisor of the following municipal titles: Commissioner of Public Works, Town Highway Superintendent, Town Engineer, Town Comptroller, and Town Clerk, are also hereby authorized to execute any necessary agreements or certifications on behalf of the Town of Poughkeepsie with New York State DOT in connection with the advancement or approval of the project identified in the state local agreement. Resolved that a certified copy of this resolution to be filed with the New York State Commission of Transportation by attaching it to any necessary agreement in connection with the project, and it is further resolved this resolution shall take effect immediately. So moved.
Second.
Any discussion? Motion has been made and properly seconded. All in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0.
Be it resolved, the Town Board of Town of Poughkeepsie is hereby establish a standard workday for elective and appointed official, which shall not be less than 6 hours per day. Be it further resolved that the standard work week shall be Monday through Friday. Be it further resolved that the following is a list of elected officials with their term expiration date. Workday, Todd Tancredi, Supervisor, 12/31/15, 8 hours a day. John J. Baisley, First Ward Councilman, 12/13/31/15, 6 hours a day. Joseph Conti, Third Ward Councilman, 12/31/15, 6 hours a day. Michael Savone, Fourth Ward Councilman, 12/31/15, 6 hours a day. Stefan Krakauer, Fifth Ward Councilman, 12/31/15, 6 hours a day. Ann Shershen, Sixth Ward Councilwoman, 12/31/15, 6 hours a day. Karen Schuber, Receiver of Taxes, 12/31/17, 8 hours a day. Felicia Salvatore, Town Clerk, 12/31/15, 8 hours a day. Mark Pfeiffer, Superintendent of Highways, 12/31/17, 8 hours a day. Paul O'Sullivan, Town Justice, 12/31/15, 6 hours a day. Paul Banner, Town Justice, 12/31/15, 6 hours a day. Be it further resolved that the following is a list of appointed officials with their term expiration date, workday. James Wadowitz, Comptroller, 8 a.m. to 4 p.m., 1 hour lunch, term ends 12/31/15, 8 hours a day. Be it further resolved that commencing January 1st, 2014, the elected or appointed official shall record his or her work activities for a period of 3 consecutive months, which will include matters outside of normal working business hours for the purpose of actually attending to official duties, including to responding to an emergency, attending an employer-sponsored event or meeting with, or responding to members of the public on matters of official business. And be it further resolved that said record shall be completed within 150 days of taking office and shall be submitted within 100 days to the clerk of the governing board. And be it further resolved, the town clerk is authorized and directed to certify the standard work day and reporting resolution as presented to this town board. So moved.
Second.
Motion's been made and properly seconded. Any
Discussion. I am not on this list
Because you're not part of the retirement package.
because I am on
Do you want to be on the list?
police
Right.
pension.
Yeah.
And
Right.
because I'm on that, I'm barred from participating in this pension. So I am not required to do this, which I think means that I don't have to work 6 hours.
Nope.
I can get away with one.
You have to work 8.
No, that's not the way.
That's not what that means? Okay.
Good try, though, Bill.
Any other? Motion has been made and properly seconded. All in favor?
Aye.
Opposed? Motion carries 5-0.
Notification.
This is just notification from the town attorney, from Eric Hollerman, planner, on the Springside North Neighborhood Development, the seeker application. Okay. So the next one would be 9. Be it resolved that the Town Board of the Town of Poughkeepsie does hereby approve the application submitted by Pam Kingsley to hold a block party on Conklin Street between its intersection with Main Street, Channingville Road, and Lawson Street on August 16, 2014, from 2 p.m. to 10 p.m., and does hereby authorize the Town of Poughkeepsie Police Department Traffic Division to close said street, but allowing access for emergency vehicles from 2 p.m. to 10 p.m. Be it further resolved that the Town Board of the Town of Poughkeepsie does hereby waive the open container law in the event alcoholic beverages are served. So moved.
Second.
Shannonville Road should not be on there. It's Main Street.
Just Main Street?
Main Street.
What about Lawson Street, Jay?
That's the other side.
So we need to make an amendment, Jim? No? So I'd propose,
That's the way she wrote it on the application, so that's why Mary probably typed
Yeah,
it that
Shannonville's all
way.
the way up top
I'd
of it.
make an amendment to remove Channingville Road.
Second.
All in favor?
Aye.
Aye.
Opposed? Motion carries. On the main resolution, All in favor?
Aye.
Opposed? Motion carries 5-0.
Newsom.
Be resolved, Town Board, Town of Poughkeepsie does hereby approve the application submitted by Colleen Flanagan to hold a block party on Orchard Park on July 26, 2014, with a rain date of July 27, 2014, from 12 noon to 11:30 p.m., and does hereby authorize the Town of Poughkeepsie Police Department Traffic Division to close said street, but allowing access for emergency vehicles from 12 noon to 11:30 p.m., and be it further resolved that the Town Board, Town of Poughkeepsie does hereby waive the open container law in the event alcoholic beverages are to be served. So moved.
Second.
Motion's been made and probably seconded. Any comments? I have a question. If it's a block party and the town of Poughkeepsie approves it, does that make us the responsible person if there's problems with the new law?
Yes,
So you're going to get charged if it's a nuisance? Is that what
Just-
you're saying?
Just wondering.
Supervisor?
Just wondering. We might want to get these done before the new law kicks in. Motion's been made and probably seconded. All in favor?
Aye.
Aye.
Opposed? Abstentions? Motion carries 5-0.
Be it resolved, the Town Board of the Town of Poughkeepsie does hereby authorize William T. Donahue on behalf of Hudson Valley Historical Miniatures Guild Scale Modelers Association to post 10 temporary signs 14 days prior to the event on October 18th, 2014, at the Poughkeepsie Elks Club, and to set up 5 directional signs on the day of the event, provided they are not sandwich board signs, with all the signs to be retrieved within 1 week following the event. So moved.
Second.
Motion has been made and properly seconded. Any discussion? Didn't they used to use sandwich board signs?
I think you did at one time.
Okay. Now that they're not, I'm good with it. All in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0.
Before you start the next one, at the top of the second page, the blank in caption should be 19,000, 620.
19,000 what?
620. Pardon me, thanks.
And do we just read the resolution, or do we have to read the resolution, the whole thing?
You got to read, unfortunately, the whole thing.
It's top of the second page.
And it's Stefan's turn?
Yes.
19,620.
Yes.
Great. All right. At a regular meeting of the Town of Poughkeepsie, Dutchess County, New York, held at Town Hall in Poughkeepsie, New York, on the 9th day of July, 2014, at 7:00 p.m. prevailing time. The meeting was called to order by Deputy Supervisor Stefan Kracker. Upon roll being called, and the following were present: Councilman Baisley, Councilman Carlos, Councilman Phone, Councilwoman Shearshin, and Deputy Supervisor Krakauer. The following resolution was offered by
Stefan Krakauer.
Who moved its adoption, seconded by
Second.
Councilman Carlos. Resolution dated July 9, 2014, a resolution appropriating $19,620 of the Town of Poughkeepsie, Dutchess County, New York, to pay the secret costs relating to a map plan and report in connection with the proposed increase and improvement of facilities of the Country Club Sewer District. Whereas Section 202B of the town law authorizes any town to prepare a map plan or report, including an estimated cost in connection with the increase and improvement of facilities of an existing improvement district, and whereas it has been proposed to increase and improve the facilities of the Country Club Sewer District in the town of Poughkeepsie, Dutchess County, New York, the sewer district, and whereas by Resolution 1218, number 2 of 2013, this board authorized Morris Associates to prepare a map plan and report at a cost not to exceed $12,000 or $19,000?
That was previously.
Okay, $12,000. And whereas it appears that an environmental review of this project under SECRA is required, and whereas it is now desired to further authorize and provide for the preparation, receipt, and analysis for required cultural resources and archaeological study and wetland delineation and endangered threatened species evaluation in connection with the SECRA review of this project, and whereas it is now desired to appropriate monies of said sewer district to pay the cost of the aforesaid preparation of map plan and report for said improvements to said sewer district and the secret review referred to above in accordance with the provisions of Section 202B of the town law, now therefore be resolved by the affirmative vote of not less than a majority of the total voting strength of the town board of the town of Poughkeepsie, Dutchess County, New York, as follows. Section 1, the appropriation of $19,620 for the map plan and report is hereby ratified, and there...
That should remain as 12,000.
Okay. I thought the second page, 12,000 was changed.
Right, the 19 is the total of the three items.
All right. The appropriation of $12,000 for the map plan report is hereby ratified, and there is hereby appropriated the additional total sum of $7,620 of monies of the Country Club Sewer District in the town of Poughkeepsie, Dutchess County, New York, to pay the cost of the aforesaid secret review as it relates to the increased and improvement of facilities of said sewer district in said town, including in particular a fee not to exceed $3,620 payable to Black Drake Consulting for an archaeological and cultural resources study pursuant to its proposal, and a fee not to exceed $4,000 payable to Ecological Solutions LLC for a wetland delineation and endangered threatened species habitat assessment per its proposal, Section 2. In the event that such improvement shall be authorized pursuant to the provision of Section 202B of the town law, the expenses incurred for the preparation of the map plan report and secret review shall be deemed to be part of the cost of the increase and improvement of such sewer district. It is reasonably anticipated that such expenses shall be reimbursed from the issuance of sealed bonds and/or bond anticipation notes in anticipation thereof. Section 3 of this resolution shall take effect immediately. The question of adoption of the foregoing resolution was duly put to a vote on a roll call, which resulted as follows.
Councilman Baisley?
Hey,
Councilman Carlos?
Yes.
Councilman Safon?
Aye.
Councilman Krakauer?
Aye.
Councilman Krakauer?
Aye.
And Sheershin? Councilwoman Sheershin?
Aye.
Motion carries 5-0. Tell you.
whereas the Town Board of Town of Poughkeepsie has received a short environmental assessment form regarding the decommissioning of the Country Club Estates Sewer District Plan in connection of the district to the Arlington Sewage Treatment Plant, as well as documentation regarding the financing of this project. And whereas after review of the submittals and description of the action, the Town Board makes the following determination. 1, that this project will require secret review. 2, the proposed action is an unlisted action. 3, the following appear to be the involved agencies: the Town Board, Dutchess County Health Department, the New York State Department of Environmental Conservation, New York State Department of Transportation, New York State Environmental Facilities Corporation. 4, the Town Board wishes to assume lead agency status in connection with the secret review of this project, and hereby declares its intent to be the lead agency unless an objection is received from an involved agency within 30 days of the mailing of the notice of such intent. 5, the Town Board directs the Planning Board to circulate a lead agency coordination notice among the various involved agencies together with the environmental assessment form. So moved.
Second.
Motion has been made and properly seconded. Any discussion? All in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0.
The next item I have is a notification. The following claim has been referred to legal: Donald Kramer versus the town.
No.
No, number 14 is next.
Arlington Fire Department easements, agreements.
10,
Oh, yeah.
12, 14,
Okay.
20 pages long.
Want to read this one?
Is that?
Okay. Oh, I got it.
I'm not reading it.
Whereas the Town Board of the Town of Poughkeepsie, the town, wishes to enter into a written agreement with the Arlington Fire District, AFD, to formalize their agreement as to the design, construction, and installation of certain drainage swales, catch basins, and related piping and other equipment, collectively the drainage system, deemed advisable to resolve certain drainage issues related to water runoff emanating from Mountain View Road and transversing certain property commonly known as 15 Mountain View Road, Poughkeepsie, Dutchess County, New York, 12603. Section 6261, Block 1, and Lot 172832, the Califano property, and owned by Joanna Campolone and Joseph Califano, collectively Campolone and Califano, and certain property commonly known by the Arlington Fire, known as the Arlington Fire District Station 1 Headquarters, 11 Burnett Boulevard, Poughkeepsie, Dutchess County, New York. Section 6261, Block 1, and Lot 155830, the AFD property, and owned by AFD now. Therefore, be it resolved that the Town Board of the Town of Poughkeepsie does hereby authorize the execution of an intermunicipal drainage agreement, the IMA, with AFD, citing forth certain terms and conditions as to the cost, reimbursement, liability, and certain construction obligations with respect to the drainage system, and in substantially the form attached hereto as Exhibit A, the execution of which is expressly subject to and conditioned upon the town's receipt and acceptance of a drainage easement from Campolone and Califano over the Califano property, the Califano easement, in substantially the form attached hereto as Exhibit B, and B, a drainage easement from AFD over the AFD property, the AFD easement, in substantially the form attached hereto as Exhibit C. In each case, for the purposes of constructing, installing, and maintaining the drainage system, and the towns entering into a separate agreement with Campolone and Califano with respect to the repair of the driveway located on the Califano property, the C&C agreement, in substantially the form set to, attached hereto as Exhibit D, and be it resolved that the town board of the town of Poughkeepsie does hereby approve and authorize the execution of the C&C agreement, and does hereby approve and authorize the acceptance of the Califano easement and the AFD easement, and be it resolved that the execution of the IMA and the C&C agreement is part of an ongoing administration of the town affairs involving no change in policy which might adversely affect the environment, and it is a Type 2 action for which no environmental review is required. And be it further resolved that the supervisor is hereby authorized to execute both the IMA, the CC agreement on behalf of the town of Poughkeepsie. So moved.
Second.
A motion has been made and promptly seconded. Any comments on the resolution? All in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0.
Whereas the Town Board, Town of Poughkeepsie finds that it is in the best interest of the taxpayers of the town to conservatively maximize the income earned on the town's general fund monies, and whereas the town has a current banking relationship with the Key Bank, N.A., now therefore be it resolved that the Town Board, Town of Poughkeepsie does hereby authorize the supervisor or the comptroller or his designee to execute the applications, contract resolutions, and other documents required to establish a Key Bank Capital Markets account to invest in U.S. Treasury bills and notes and other statutorily permitted by New York State municipal investments, which investments will be held in the name of the town in a Key Bank safekeeping account, all consistent with the provisions of General Municipal Law 11 and the other applicable statutes, laws, and rules and regulations. And be it further resolved, the Town Board authorizes Supervisor Todd N. Tancredi and Comptroller James N. Wadowitz to be the signatories on these accounts, and be it further resolved that the execution of these documents involves ongoing town administration, which is a Type 2 action requiring no secret review. So moved.
Second.
A motion has been made and properly seconded. Any discussion? All those in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0.
Was 16? Removed.
16 was removed, yep.
Removed, okay. Whereas Thomas W. Colgan, by Resolution 1017-3 of 2012, was granted a provisional appointment to the position of Water Distribution System Operator Grade D. Now therefore be resolved, the Town Board of the Town of Poughkeepsie does hereby rescind Resolution 5710 of 2014 at the request of the county due to an error in the date of permanent hire noted previously, and be further resolved that the Town Board of the Town of Poughkeepsie does hereby appoint Thomas W. Colgan as a permanent water distribution system operator, grade D, pursuant to the notice from Dutchess County Department of Personnel, a copy of which is attached hereto, subject to a probationary period of not less than 8, no more than 26 weeks per civil service law, effective retroactively to April 11, 2014. So moved.
Second.
The motion's been made and properly seconded. Any discussion? All those in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0. Whereas James R. Normandine, by Resolution 620, number SC3 of 2012, was granted a provisional appointment to the provision of water distribution system operator grade D. Now, therefore, be resolved, the Town Board of the Town of Poughkeepsie does hereby rescind Resolution 57, number 11 of 2014 at the request of the county due to an error in the date of permanent hire noted previously. And be it further resolved that the Town Board of the Town of Poughkeepsie does hereby appoint James R. Normandine as permanent water distribution system operator grade D pursuant to the notice from the Dutchess County Department of Personnel, a copy of which is attached hereto, subject to a probationary a period of not less than 8, no more than 26 weeks per civil service law, effective retroactively to April 11, 2014. So moved.
Second.
Discussion? Motion's been made and properly seconded. All in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0.
Whereas an order remedy, a copy of which is attached here too, has been issued to property located at 107 East Cedar Street, Town of Poughkeepsie, State of New York, pursuant to Chapter 159 of Town of Poughkeepsie Town Code, and whereas said order remedy has not been complied with, now therefore be resolved, the Town Board of Town of Poughkeepsie is hereby set the 23rd day of July 2014, 7 p.m., Town Hall, Town of Poughkeepsie, 1 Over Rock Road, Poughkeepsie, New York, as and for the time, date, and place of a public hearing to consider recommendation from zoning administrator that the town or its contractor remove and as needed continue to remove all garden waste, fallen tree limbs, cut and continue to cut the grass to a height not to exceed 6 inches, and maintain throughout the growing season so as not to become overgrown and unsightly, the cost of which work shall constitute a lien and charge on the above real property until paid, satisfied or discharged, and shall be collected in the same manner as other town charges. So moved.
Second.
Motion has been made and properly seconded. I think we need to hear from Sarah Davis on this.
The phone was actually mowed. I was there today, and I do have a contact.
Okay.
Oh, good.
Okay. So this, was this set a date for public hearing? All right, so then I guess we just vote it down.
Table this one, Sarah?
Vote it down or table?
I would vote it down.
Okay.
Well, if we hold it, if they don't cut it again, we have it on
But the-
record,
I mean,
though.
there is always a chance they stop if the bank gets to a certain point in the.
Yeah, I would rather we-
They'll just
Just-
stop.
I would rather we vote on it, so if they don't cut it again, we can move forward on it.
Why don't we table
Setting a
it?
date, I'd have to put it in the paper.
Oh,
no?
right.
Yeah, we don't want
We don't want to waste money.
So,
Ben-
all right, then just table it then
Been cured.
indefinitely.
Better thing to do is to either vote it down or withdraw it. I mean.
I would make a motion.
Having these people, well, pardon me.
I'd make a motion to withdraw the resolution.
Second.
Motion's been made and properly seconded. All in favor?
Aye.
Aye.
Opposed? Abstentions? Motion carries 5-0.
Do we have a fix on this new one?
Yes.
102 Creek Road?
No, that one I have nothing.
Okay. Whereas orders to remedy, copies of which are attached here too, have been issued for the property located at 102 Creek Road, Town of Poughkeepsie, State of New York, pursuant to Chapter 159 of the Town of Poughkeepsie Town Code, and whereas said orders to remedy have not been complied with, now therefore be it resolved that the Town Board of the Town of Poughkeepsie does hereby set the 23rd day of July, 2014 at 7 p.m. at the Town Hall of the Town of Poughkeepsie, 1 Over Rock Road, Poughkeepsie, New York, and as for the time, date, and place of a public hearing, to consider a recommendation from the zoning administrator that the town or its contractor remove as needed and continue to remove all garden waste and fallen tree limbs, cut and continue to cut the grass to a height not to exceed 6 inches, and remove and continue to remove all solid waste, debris, and litter, all at the above property, so it will not become overgrown and unsightly, the cost of which shall constitute a lien and a charge on the above real property until paid, satisfied, or discharged, and shall be collected in the same manner as other town charges. So moved.
Second.
Motion has been made and properly seconded. Any discussion?
Nope.
All those in favor?
Aye.
Opposed? Abstention? Motion carries 5-0.
Whereas in order to remedy, a copy of which is attached hereto has been issued for property located at 32 Lindbergh Place, Town of Poughkeepsie, State of New York, pursuant to Chapter 159 of the Town of Poughkeepsie Town Code. And whereas said order to remedy has not been complied with, now therefore be it resolved, the Town Board, Town of Poughkeepsie is hereby set the 23rd day of July, 2014, at 7 p.m. at Town Hall, Town of Poughkeepsie, 1 Over Rocker Road, Poughkeepsie, New York, as for the time, date, and place of a public hearing to consider recommendation from the zoning administrator that the town or its contractor remove or as needed continue to remove all garden waste, fallen tree limbs, cut and continue to cut the grass to a height not to exceed 6 inches and maintain throughout the growing season so as not to become overgrown and unsightly, the cost of which work shall constitute a lien and charge on the above real property until paid, satisfied, or discharged, and shall be collected in the same manner as other town charges. So moved.
Second.
Motion has been made and properly seconded. Any discussion? I I have a question. Whatever happened to that good neighbor law that Senator Gibson had come in here touting is this would now make the banks responsible and make them good neighbors and blah, blah, blah. Did that ever, anything ever go anywhere with
No,
that?
it's still in committee.
Really?
Yeah, they have 2 years to get through the system.
They'll cut your grass in between.
All right, so much for that. Sarah, did you have something to add on this?
Actually, this was cut when I went there today, but there's no postings, I don't have any name, and I know that the complainant who complained about this in the beginning said he was tired of cutting it. He didn't leave his name, I don't know who that was.
So you're not sure if it was,
Cut, I don't know who cut it.
so why don't we adjourn this one for a month and see what happens?
Yeah, we could,
Okay, I'd make a motion to adjourn this to the first meeting in August.
Second.
Motion's been made and properly seconded. All in favor?
aye.
Opposed? Abstentions? Motion carries 5-0.
Whereas orders to remedy, copies of which are attached hereto, have been issued for the property located at 83 Fairview Avenue, Town of Poughkeepsie, State of New York, pursuant to Chapter 159 of the Town of Poughkeepsie Town Code, and whereas orders to remedy have not been complied with, now therefore be resolved, the Town Board of the Town of Poughkeepsie does hereby set the 23rd day of July, 2014, at 7 p.m. at the Town Hall, Town of Poughkeepsie, 1 over Rocker Road, Poughkeepsie, New York, as for the time, date, and place of a public hearing to consider recommendation from the zoning administrator that the town or a contractor remove and as needed continue to remove all garden waste and fallen tree limbs, cut and continue to cut the grass to a height not to exceed 6 inches, and remove and continue to remove all solid waste, debris, and litter, all at the above property, so it will not become overgrown and unsightly, the cost of which work shall be constitute a lien, and charge on the above real property until paid, satisfied, or discharged, and shall be collected in the same manner as other town charges. So moved.
Second?
Motion has been made and properly seconded. Any discussion? All in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0. Whereas in order to remedy, a copy of which is attached hereto and has been issued for the property located at 6 Alexander Boulevard, Town of Poughkeepsie, State of New York, pursuant to Chapter 159 of the Town of Poughkeepsie Town Code, and whereas said order of remedy has not been complied with, now therefore be it resolved, the Town Board of the Town of Poughkeepsie does hereby set the 23rd day of July, 2014, at 7:00 p.m. at the Town Hall, Town of Poughkeepsie, 1 over Rocker Road, Poughkeepsie, New York, as and for the time, date, and place of a public hearing to consider a recommendation from the zoning administrator of the town or its contractor remove as needed, remove and as needed, continue to remove all garden waste, fallen tree limbs, cut and continue to cut the grass to a height not to exceed 6 inches, and maintain throughout the growing season so as not to become overgrown and unsightly, the cost of which work shall constitute a lien and charge on the above real property until paid, satisfied, or discharged, and shall be collected in the same manner as other town charges. So moved.
Second?
Motion's been made and properly seconded. Any discussion? All in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0.
Whereas order to remedy, copy of which are attached hereto, have been issued to property located at 16 West Dogwood Drive, Town of Poughkeepsie, State of New York, pursuant to Chapter 159 of Town of Poughkeepsie Town Code, and whereas said orders to remedy have not been complied with, now therefore be resolved. The Town Board of Town of Poughkeepsie is hereby set the 23rd day of July, 2014, 7 p.m., Town Hall, Town of Poughkeepsie, 1 over Rocker Road, Poughkeepsie, New York, as and for the time, date, and place of a public hearing to consider recommendation from the zoning administrator that the town or its contractor remove and as needed continue to remove all garden waste, fallen tree limbs, cut and continue to cut the grass to a height not to exceed 6 inches, and remove and continue to remove all solid waste, debris, and litter, all at the above property, so will not become overgrown and unsightly, the cost of which work shall constitute a lien and charge on the above real property until paid, satisfied, or discharged, and shall be collected in the same manner as other town charges. So moved.
Second.
Motion has been made and properly seconded. Any discussion? I just want to, I've thanked her before, but I want to thank Sarah Davis for the work that she does, because prior to her being the zoning administrator in the town, a lot of this stuff didn't happen. It sort of just not even flew under the radar. It just never got addressed. So I appreciate the work that you do. I appreciate the fact that you're out there all the time, that you're vigilant in making sure that people follow just the basic rules and regulations that we have. And I think you do it fair and even-handedly. So thank you again, Sarah.
Thank you. This item seems to be a copy of the short form seeker application for that item we tabled to land use.
Vote on the last.
It's the seeker,
No, we're still on the.
Yeah, so it's,
For 25 is a notice of claim.
We haven't voted on 24 yet.
Yeah, I didn't think so.
No. All in favor?
aye.
Aye.
Opposed? Abstentions?
You got thanking her.
Motion carries 5-0. Yeah, I was.
Sorry.
All right, next one.
Is 24?
So, 25 is the next.
25 is notice of claim.
Yeah, it's a
25 is
notice of claim.
26
25
is
is just
the
notice of claim.
Just a notice of claim?
Yep.
Okay, now, 26. Be it resolved that the town board of the town of Poughkeepsie does hereby grant special consent to the following items, to wit. 1, set date for public hearing, 159 North Grand Avenue, property maintenance. 2, appoint Carl Osterman, part-time permanent court attendant. 3, notification. The following notice of claim has been referred by the town clerk to legal, A. Wolven, Tom versus Town. And be it further resolved that upon the objection of any member of the town board, an item may be removed from the list and voted on separately. So moved.
Second.
Motion's been made and properly seconded. All in favor?
Aye.
Aye.
Opposed? Abstentions? Motion carries 5-0.
Whereas orders to remedy, copies of which are attached here too, have been issued for property located at 187 North Grand Avenue, Town of Poughkeepsie, State of New York, pursuant to Chapter 159 of Town of Poughkeepsie Town Code. And whereas said orders to remedy have not been complied with, now therefore be it resolved, the Town Board, Town of Poughkeepsie, does hereby set the 23rd day of July, 2014, at 7 p.m. at Town Hall, Town of Poughkeepsie, 1 Over Rocker Road, Poughkeepsie, New York, as and for the time, date, and place of public hearing to consider recommendation from the zoning administrator that the town or its contractor remove and as needed continue to remove all garden waste, fallen tree limbs, cut and continue to cut the grass to a height not to exceed 6 inches, and to remove and continue to remove all solid waste, debris, and litter, all at the above property, so it will not become overgrown and unsightly, the cost of which work shall constitute a lien and charge on the property, real property until paid, satisfied, or discharged, and shall be collected in the same manner as all other town charges. So moved.
Second.
Motion has been made and properly seconded. All in favor?
Aye.
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 Opposed? Abstentions? Motion carries 5-0.
Be resolved, the town board of the town of Poughkeepsie does hereby appoint Carl Osterman to the position of permanent part-time clerk attendant at a salary of $15.15 per hour, effective immediately. So moved.
Second.
Motion's been made and properly seconded.
Didn't you just leave?
I think he was retired recently from the town police department, right? Yeah.
Then he was there and he left and he must have come back again.
Couldn't stay away. All in favor?
Aye.
Opposed? Abstentions? Motion carries 5-0. And SC3 is a notice of claim referred to legal, Tom Wolven v. Town of Poughkeepsie. I believe, correct me if I'm wrong, this concludes the regular agenda items. Do we have a, wow, good. I'd make a motion to suspend the rules for public comment.
Second.
Motion's been made and probably second. All in favor?
Aye.
Aye.
Anybody like to speak regarding any town issues? Mr. John McBride, come on down.
John McBride, 29 Sharon Drive. Most of you know what I'm going to speak about. It's a very serious subject. Most of the time when I tell somebody, they stand there in shock and don't know what to say. I've got a prepared written speech I'll just read, and when I get done, you can ask any questions. I'll answer them as best I can. For the second time in 3 years, in 2 different leagues, I've had to pull my son from his Little League team because I had evidence the coach was using illegal drugs, and the league president would not or could not remove the coach from the field. 2 different leagues, 2 different coaches, 2 different league presidents, and the same response. Before I tell you these stories, I want to say that I'm not going to name any names. Don't even ask. No child should ever have to suffer through one of their parents being publicly named as a drug addict. Also, some of you on the board know me and know that my family has been victimized over and over again by drug addicts over the last 20, 25 years. I have more horror stories than any of you can imagine, and I'm fed up with people who get themselves hopelessly addicted to drugs, cause physical, emotional, and financial harm to friends, family, and innocent people, and then just expect everyone to understand they have an illness and can't control their actions. But I'm also fed up with people in power who continue to give the drug addict the benefit of the doubt. leaving the law-abiding victims to continue to suffer at the hands of the drug addict and are left with no other choice other than to endure the endless trauma or take the law into their own hands. And these are judges, law guardians, elected officials, counselors, and yes, Little League organizers. 3 years ago at my son's Little League game, I noticed a friend's ex-husband in the dugout with my son. I went to my friend and asked her what her ex was doing in there. I knew he was doing drugs. She didn't know, and this is the first time she saw him with the team. Her ex-husband was court ordered to go back to rehab, and his visitation was limited to 4 days per month until he obeyed that court order. My friend went to the head coach and privately told him that his assistant was a drug addict, and the head coach refused to listen. The following week, she brought a stack of paperwork, a folder an inch thick, with failed drug tests, orders of protection, multiple suspensions of visitation, a no-contact order issued by a family court judge for over a year with his own children. And the head coach still refused to listen, saying that nobody else volunteered and he needed the help. I was outraged. I confronted the head coach myself and told him I didn't want a drug addict coaching my son, and the head coach told me that the man had a right to see his son and that people should give him a chance to redeem himself. When I called the league president, he told me that if I was unwilling to volunteer to help out in the dugout, then I had no right to criticize any other coach. So it was apparently league policy to allow a drug addict who was found by a judge to be too dangerous to be around his own son to coach other children. My 8-year-old son just wanted to play baseball, and I didn't know how I was going to tell him it was too dangerous and that I was going to pull him from the team. But as luck would have it, on the day I was going to pull him from the team, he broke his arm on the school playground. So problem solved. I didn't have to do or say anything. I just sent a picture of my son with a cast on his arm to the coach, and that was it. I left. But I've always wondered what happened on that team, and I felt guilty for not telling the other parents what I knew. 2 years later, we signed my son up to another league, and he had some great coaches. 3 seasons in a row, I made sure I volunteered to help out in the dugout so I could assess the coaches myself, and I worked with 3 great coaches over 2 years who all seemed fine. But this past spring, I noticed the coach's personality was unpredictable, hot-headed, high-strung, paranoid, and even bipolar. He got mad at me for something, then shook my hand the next day as if nothing had happened. Got mad at me a second time over nothing, and then asked for my help at the next game. And they got mad at me a third time and asked me to leave the dugout during the game, and that was it for me. This guy reminded me too much of all the former drug addicts I've had to deal with in my life. I had no evidence of that, but that's just how I felt. I spoke with my son, who agreed with me that the coach was just plain strange, so I pulled him from the team. 2 weeks later, while working my part-time job as a bartender, I saw this coach pull into the driveway, have a quick exchange with someone sitting in the parking lot, and get back in his truck and drive off. I said, "What the heck was that?" And another bartender identified the guy sitting in the parking lot as one of the biggest drug dealers in town. Happened right in front of me. And I sat there in shock, and my suspicions were confirmed at that point, and I was up all night, sick to my stomach, and decided in the morning that it would be irresponsible of me to not warn the league and the other parents about what kind of man was coaching their sons. Again, this league president refused to take action and said it was my word against the coaches. I asked what kind of investigation would take place, such as random drug testing, and the league president just said they couldn't do that. So 2 different league presidents in 2 different leagues have no ability to even investigate charges of illegal drug use by a coach and will in fact defend the coach to the hilt in the face of any complaint by a parent. Any parent who would drop their kid off at a ball field to be supervised by a coach in either of these leagues should know that there are no guarantees their child will be safe at the ball field. My son will never play in another little league in this area, not with people like this running the show. And both of these leagues play on town ball fields. Since both of these leagues refuse to even investigate these types of complaints, and since they both seem more interested in protecting the league from lawsuits than protecting the kids who play in the league, I think the town of Poughkeepsie Town Board should take some kind of action. I'm suggesting that all volunteer coaches be required to submit to random drug testing a couple of times per year. I think that just making that the law would scare most of the problem coaches away. And I don't see any alternative to that. And if you have a couple hours, I'll start telling you some of the horror stories I've been through with 12-year-old kids being threatened by their father's drug dealer when he couldn't pay his drug bill. Drug dealers don't take people to small claims court. They get their money any way they can. And this past spring, my neighbor brought his son to a ball game, and apparently the coach was dealing with a loan shark who threatened to send his representatives to the ball field to collect his money. The police were called and showed up at the game. The coach was relieved of his duties. The parents were informed just before the game, so they had the option of taking their kids and leaving. Most of them felt safe with the 2 police cruisers parked at the ball field, and they stuck around. But if a coach is using illegal drugs, what kind of friends is he going to have? I don't want my son standing between the coach and his drug dealer. Now, as I said, I felt guilty the first time when I just walked away and said nothing. I'm here to tell you we've got a problem with the way that these complaints are addressed. I think the town board needs to take over on this. But I'm just going to make sure my son is safe, and I'm walking away. Whatever you guys decide to do is up to you. I've told you there's a problem. And as I said, it would be irresponsible of me just to walk away a second time without informing other parents. And that responsibility is now filled. I'm done. And like I say, I've been through too many problems over the last 25 years. I can't deal with something like this again. If one of you guys want to take over on this cause, that's up to you. But I've laid it out there. It's up to you. And I'll take any questions. Everybody's sitting there in shock, just like as usual. If it happened to me twice, how often is it happening?
Anybody?
You gave us something to think about, John, and we'll
Yeah.
definitely talk about it and among ourselves and see what we can do.
All right.
And I do think that the town board, the town's concern is to make sure that everybody's safe and in a safe environment. I do think that that's also the concern of the people that run the leagues. One suggestion that I have for you on your side of it is if you see something like that, report it to the town police, see if they can do something with it. And I don't know, you may or may not have done that.
In the first case with the family court paperwork that showed that he was a drug addict, not even allowed to see his own kids, how much evidence do you need to pull this guy off the ball field?
Well, no, I'm talking about if there's a transaction.
And the second one, there was not enough evidence to convict him of a crime, but plenty of evidence to make me keep my
there's a
son away
Dutchess
from him.
County Drug Task Force. You alert the police. You let the police know about what's going on. I have 2 young kids. My daughter plays soccer. I have a concern about who interacts with my children, whether it's a coach or other parents or anything else. So I understand where your concern is coming from. I think the town will look at it and see what we can do. I know from one of the leagues, I spoke to the president of the league, and he was looking at it to see within their organization what other areas have done and what they can do. So I don't think it just completely fell on deaf ears, at least for the second one that you spoke to. So, and again, at the end of the day, I think the overwhelming majority of people that get involved in that are very, very good people putting everything they have into it to be a part of their children's lives, but you don't want somebody that's going to put your kid at risk anywhere near your children or anybody else's. So I appreciate the fact that you put your neck out there a little bit to call people out, because I think that's important, because too many times people sit back and say, it's not my problem, I don't want to get involved.
I got a lot of phone calls with people worried about lawsuits and we can't do that.
But I do think that you have brought the proper attention to it. And again, I can only speak for one of the leagues because I only spoke to one of the league presidents, and I do think that he is looking at it to figure out what the league can do, and the town will look at it to see what we can do from a town's point of view. They're using our fields, but we don't run the league, so we can look at what we're able to do. And I'd ask the town attorney to take a look at that. So thank you. Thank you,
One
Mr.
last thing,
McBride.
I've talked to a lot of people since this happened May 24th, and I would just like to know what happened to all the good men in the world that would stand up for what was right and what was wrong and not worry about cowering in the face of a lawsuit or some type of ridicule and just say, oh, it's not my problem, and walk away. It seems like the greatest generation is fading away, and I think a lot of people in this town have got to go home and look themselves in the mirror. I'm going to sleep well tonight. There's a lot of other people who should think twice about what they're doing and what their motivation is for not doing anything.
Thank you.
Thanks, John.
Doreen.
I'd just like to say that I'm glad that the board didn't take any action on the LVS Dahlia subdivision, because I was here at that meeting also. I don't know how anybody could have thought that the board was in favor of what was presented, and this has been going on for a very long time, so I don't see what the difference is that for 1 month the planning board wasn't having a meeting. So glad to see that that you're going to take another look at it and just didn't vote on it. So thank you.
Anybody else?
Hi, I'm Susan Salem. I've lived in this area for 50 years. I had 3 children I brought up in these local schools, and I have 10 grandchildren. And the more I find out about this problem, this drug problem with the coaches and the Little League, something has got to be done. I don't know what the town board can be done, but they are using our ball fields. And I really feel that it has to be looked into by the town, not just by this ball league. And if they're having a problem getting good people to volunteer, if these parents find out that there's not going to be a league, maybe they'll step up and volunteer. I've heard from the, I'm not going to name a law enforcement person, say there's nothing they can do about something like that. And what are we going to do? Wait until something happens in our town, like what happened in Wappingers, where those 3 little boys were killed because these wacko drug dealers were trying to collect their money? I mean, to have something like that, it's possible for something like that to happen. We've got to do something. We can't just stand by and let this continue. Thank you.
Thank you. Anybody else? Sir?
Good evening. I'd like to read a very brief statement. My name is Greg Dawn. I live at 80 Hillis Terrace in the 2nd Ward in the town of Poughkeepsie. I first appeared before the town board on September 19th, 2013, regarding a major drainage problem on Upper Hillis Terrace. I'm here this evening to ask the board what has been done in the last 10 months to address the problem. A lot has happened since I brought this matter to your attention last September. We continue to have flash floods and major storms in the Northeast, and we just had the first major hurricane come up the East Coast. The house behind me was just sold, and I no longer have a place to pump the water that has been flooding my property for the past 35 years. In the last several months, I discussed my drainage problem with 2 local contractors who both informed me they cannot do anything about my drainage problem until a storm drain system is developed by the town of Poughkeepsie. One of the contractors even arranged a meeting at my home with Mr. Pfeiffer in the town highway department in May, who I have not heard from since. I would appreciate your comments on this matter.
There's no drainage on the upper part. There's no basins, there's nothing.
Which is, it's a problem in certain areas of the town, and it goes back to when these projects were first built out, and there's supposed to be a process where you review them, engineers look at them, and they're developed correctly. It amazes me where you have a subdivision built out with no drainage at all, and it just boggles mind as to how that could have been improved. We, as a town, have to go back to try to correct these things after the fact. The developers left town with the money stuffed in their pockets, and it's years later. I think we've tried to be more proactive with the newer developments that come through. Sometimes it works, sometimes it doesn't. But the one thing that we've tried to do is add money to the drainage fund to be able to address these issues. We put $100,000. We moved it from $20,000 up to $100,000 last year, which isn't a lot in the grand scheme of things, but it helps to go a long way towards dealing with some of these projects. One of the things is that it's not these things didn't occur just yesterday. These are long-standing problems. They've developed over time, and so there's got to be some point in the process where we come up with a solution, and then we got to figure out whether we can pay for it. If we can't pay for it today, we got to plan long-term. I don't know where the highway department is or the engineering department is as far as figuring out a solution, but I know from my experience in my own ward that the turnaround time to try to resolve these is fairly long because the highway department goes out and looks at it. We have to have engineering. Sometimes we have to have the water and sewer departments go out and look at it to figure out the impact on all their systems. And the engineering department has got to come up with a fix. I know in my ward there was an issue that was about 30 years in the making, and they came up with a fix, but the state DOT wouldn't allow us to connect into their system without upgrading the entire system downstream, and it was going to cost $1 million plus. And we needed easements. Over the years, we've collected the easements over the properties. DOT then acquiesced and allowed us to do less of improvements downstream, and it drastically reduced the cost, and it did get fixed. So The only thing I don't know specifically where it is. I'd ask I guess since
It's
I'm
like
the
a
deputy
big-
supervisor, either I'll follow up or.
Top of Hillis Terrace is like a big bowl. You gotta go over a ridge to get into it. Once the water's there, it's clay.
Yeah.
This man's house is at the bottom of the bowl. The only way, I don't know anything about engineering, you're gonna have to put some kind of a big catch basin and a pump. It's gotta be pumped out of the hole.
Well,
I don't know how much that costs or what the engineering would be.
But that's where we need either Don Beer or Sean to go out, our associate engineer to go out and come up with a plan and tell us what the cost will be. And then from there, we have to figure out whether we can afford it. A lot of the problem is that these things aren't affordable when they're multi-million-dollar projects for, a few houses or a portion of the town. It's not affordable. But sometimes if you go at it, if you keep going at it, like I said, there's one in my ward where it's been. I went at it a number of times, other councilmen have gone at it, and it eventually came around where we had the easement plus New York State. There was a change over New York State where we were able to get the thing done. But these aren't easy fixes because they're big problems. So again, if Mark Pfeiffer went out there, my presumption is he is working on it. I can check and Councilman Carlos can check and see where that's at. But we do need engineering to get involved too, because engineering is the one that comes up with the dollar value as far as what it's going to cost us. And then bottom line is, if the plan to fix it doesn't match up with the money that we have, our only option is to either sit tight and wait or look for grants. We have a grant writer that goes out and looks for grants, pursues federal and state grants. We can have the grant writer take a look and see if there's anything available as far as grant money for these things. But a lot of times the grant money is not there. So I hate to tell you that it's not an easy fix and it may not happen in the near term, but the best we can do is take a good look at it, figure out what the solution is, and then.
What did your contractor say to you?
I had two contractors come to my home just in the last several months. The first is an excavation and construction contractor. He thought that a viable alternative might be to put some sort of retention system on my property and a pumping system, but he says there's no place to pump it to.
Yeah.
Right.
He said, and he told Mr. Pfeiffer when we met at my home, he has no choice but to pump it in the street. Mark Pfeiffer says, you can't pump it in the street. My contractor says if he doesn't pump it in the street, he's going to lose his home. I've been underwater hundreds of times. This area was developed 55 years ago. The rest of Hillis Terrace, if you go over the hill next to my home that Mr. Carlos mentioned, there's storm drains or dry wells all the way out to Vassar Road and all over the town of Poughkeepsie, but not on what we refer to as the upper circle. It's not a cul-de-sac, it's a large circle with 22 homes on it. When I first brought this matter up with the board last September, Mr. Tancredi said that he would meet with the engineering department to see what their recommendations were. Long before I came to this meeting last September, I invited the engineering department to come out to my home. Sean Crimmins came out in July of last year, a year ago. He walked around my house, he rode around the neighborhood, he took pictures, he took notes, and he disappeared. I've reached out to everyone in the town of Poughkeepsie over many years to try to get some solution to this problem, and everyone has turned their backs on me. I'm out of time now. I have no place to pump the water. The storms are coming up the coast. The neighborhood's getting flooded. My home's getting flooded. I can't tolerate it anymore. I'm going to have no choice but then to start pumping it into the street. And we're talking thousands of gallons. It's that or my basement.
The problem with pumping it in the street is you pump it in the street and you pump it into your next door neighbor's yard or property. And something like that becomes it's not an individual property issue, in my opinion. It's a town issue because when you have a number of people that have a drainage issue, that's part of the reason why the town exists. So I do think the town's got to look and figure out the solution. If Mark Pfeiffer's been out there, if Sean's been out there, my guess is that there's at least some sort of plan and process or some sort of idea as to what needs to be done to fix it. Someone just hasn't communicated that back to you, but what we'll do is make sure that we figure out what the answer is and communicate it back to you. The answer may be that we can't fix it right now.
It's fixable.
Well, it's fixable, but everything's fixable. It's a
But
matter
you
of.
dollarize things.
Well, the dollarized things is based on the reality of we have to tax people to do these things, and you can't tax. I'm trying to think of a better word.
You are taxing me.
But you can't. There's only so much you can tax people, and the reality is, if your fix is a $10 million fix, we can't tax people to fix that. So what all I'm telling you is we got to figure out what it is and what it costs, and then we got to figure out if we have the money in our budget.
Mr.
be able to do
Krakauer,
it.
I'm paying the same taxes as everyone else in the town of Poughkeepsie based on the evaluation rates, except I'm not getting the drainage. I'm not getting the same value for my tax dollar that my neighbors are on the
No, I
other
realize
side of
that.
town.
I could tell you don't worry, we'll fix it, but I'm telling you the honest answer is that we have to figure out what the problem is, what it costs, and then find the money to be able to pay for that.
You've
Just
been
like the rest of the
studying
world.
it for years. When are you going to do something about it?
Mr. Dawes, you said your contractor said some kind of a catch basin or way to hold the water, and then you're going to pump it out.
He's going to pump.
What you're looking for is a place to pump it to?
Yes. If there was some sort of drainage system, a storm drain or a sewer system on my street, a lot of it wouldn't come into my yard. But a lot of water
I
comes
asked that
into.
question, and the answer was because of the topography of that whole community, the upper circle. The only solution is to pump it over that ridge line and into the water system that goes down Hillis Terrace.
That's an obvious choice. There are other possibilities. One that was mentioned to me was that they pump it into the power lines that Central Hudson has a right-of-way on 2 doors down from me. Or put
Behind,
some-
I looked at the satellite map for your property, and you're talking about over the ridge behind, what's the name of the lady who lives just up to your right?
Brittenham owns 84 Hillis. I'm 80 Hillis.
Okay.
Their front yard goes underwater every time it floods. My backyard goes under.
Yeah, I was at your house, but you
They're
weren't
pumping
home.
into those power lines now.
They were pumping it over that ridge line.
It's not even a ridge, I don't think. It's just a tract of land that the power lines pass through that Central
Okay.
Hudson
I'll
controls.
talk again with Mark and with Mr. Wilson and see if there's some kind of solution. If there's a way to get the pumped water up over that ridge, it makes sense that it could connect into because it's downhill from there. Water flows downhill. It's not going to flow out of where they are. It's not going to go up.
When Mark Pfeiffer came out in May, I think it was May 19th, we spent quite a bit of time talking about this and surveying the area. And a couple of possibilities he mentioned is putting some sort of catch basin in front of my home, possibly 2, and connecting them to the 2 dry wells that are down around the corner in front of 84 Hillis, which only fill up with water and overflow. My comment to Mr. Pfeiffer was, that would be some solution, maybe not the perfect solution, as long as you don't allow the water to percolate into the ground. Because if you do that, then my water table comes up under my home and I lose anyways. I need something that will carry the water away.
Right. The water has to be pumped out of the bowl.
But for God's sake, do something. Don't do anything. I'm on the losing end. I can't even leave my home for a vacation or go in the hospital or go out of town. I had a flash flood last Wednesday. My backyard was within 15 minutes of pouring into my basement. Fortunately, I was there when the storm hit. I pulled out one of my many expensive pumps that I have, and I started pumping it into this adjoining property. It's a wooded area. But that house was just sold, and the new owners are going to show up any day now, and if they shut me down, I have no place to pump anymore. I'm out of time.
Is it downhill from you where you pump to? When you put your personal pump up and you pump
No,
it?
it's uphill.
You pump it uphill.
I pump it up a 20-foot ridge into a rock formation in the woods, but it's not my land.
Okay.
I should probably take the fifth on this, but.
Yeah, I was going to say, you're flooding out your neighbors. And really.
But they just sold the house. I no longer have that arrangement anymore. And as soon as I saw them outside, they stopped by last week and they were staring at my pump the day we had the flash flood. It's just a matter of time before they challenge me.
Okay.
Will somebody on the town please get back to me
I will.
within a not-too-distant future?
I will.
Thank you, I appreciate it. That's all I have.
Anybody else? Come on down.
Bill, do you have his contact number? Do you have his contact number?
Yes, I know right where he is.
Okay.
My name is Cliff Lobby, and I'm a 12-year resident here in the town of Poughkeepsie. The last 10 years, I've been the next-door neighbor of John McBride, and I've become aware of this issue with drugs in the Little League Baseball. And obviously, it's something that John is very close to. John and I agree on zero, politically speaking, but on this issue of drug addicts in Little League Baseball, we are lockstep. And I guess, and I'm embarrassed to say, this is only my third town meeting in 12 years, but I took this opportunity not only to show support to him, but to try to figure out when somebody like John does stick his neck out to talk about an issue like this. And I hear folks saying, we're going to talk about it, John. Assurances that, yes, sound good. Where is the onus now? How do I know, how does a resident like me, who has a neighbor with a sincere personal concern, how do we know that somebody is going to be held accountable, and where is the onus now? So when you all are going to talk about it, what does that mean? It seems like something has already been done. Maybe you learned about it earlier, Mr. Krakauer, and spoke with one of these leaders in Little League. So that's already happened. What's the next step? I mean, I don't understand what's going to happen next that's actually going to make this happen.
Well, then
Mr. McBride, one sec. Mr. McBride made a suggestion that there be random drug testing. Is that one of the things that's going to be discussed behind the scenes?
Well, the next step is for our town attorney to figure out what it is that we can do, because we own the parks and we license the parks to the leagues to use, so we have to figure out what we can do as far as people using our parks, whether we could impose that or not. And the other thing, and like I said to Mr. McBride, the other thing that when he spoke to me about it, I reached out to the president of the league that I know, and I spoke to him about it, and he was in the process of talking to the people within the Cal Ripken Babe Ruth organization to find out what they can and can't do as far as the league's policy. These organizations, Little League and Cal Ripken, they have a lot of rules and regulations. I'm guessing that this isn't a unique situation to the town of Poughkeepsie. So my hope is that they will have addressed this issue already in multiple other communities, and they will have a suggestion that comes back to us from there. But on our end, we're going to have our town attorney look at it and find out legally what the town could or couldn't do. So yeah, it is in process. And,
Okay,
and the
and
reality,
so
the reality is we don't always, just like the guy's flooding problem, we don't always have the answers the time you ask it, but we
Understood.
do make every effort to figure it out and to bring it back out here. We try the best we can to make sure that these things are addressed, and it is a serious concern, so.
Okay, thank you.
Anybody else? Nope. I'd make a motion to adjourn.
We don't.
Do I have a second?
Second.
All in favor?
Aye.
Meeting adjourned at
8:53 PM.
53 PM.
Wow.
You can sleep.
John Figure, see? And I can show you right where it sits on the camera. Call was his phone number. Figliosi was to the ombudsman.
Sorry about that. I really thought.